Hi, my name is Dustin Reinders. I'm the supervising attorney of the education team at Disability Rights Texas, and I'm happy to be with you today talking about guardianship and, more importantly, your other alternatives to guardianship, including supported decision making. Any conversation about alternatives to guardianship and supported decision making in the US should start with a little bit of history. And for us, that's the history of a woman named Jenny Hatch, who was the first person to have a court case where she won the right to use supported decision making instead of a full guardianship to make decisions for herself. Let's listen to Jenny in her own words.
Jenny, what do you want to tell people about the Jenny Hatch Justice Project?
I come here to help with disabilities and special needs, and this is community health center that I always love.
Jenny was an individual who was living at first in a group home. She began working at a thrift store that she loved. Over time, she wanted the right to live independently with people who she met through work. And her parents at first were a little uncomfortable with that, ended up filing for guardianship. And then with help from the for the Quality Trust for Individuals with Disabilities, Jenny was able to fight for her right to continue making her own decisions about where she lived and who she spent her time with and whether she worked. So why is it important for people to make their own decisions? You know, one thing to keep in mind is that making decisions for yourself is a learned skill, and people with disabilities can learn too. And so we all learn to make better decisions by having the opportunity to make mistakes. And so if we take away the right for people to make decisions for themselves, we're also taking away the opportunity for them to learn decision-making skills. You know, making your own decision also promotes responsibility and self-determination. It makes people healthier and better prepared to recognize and resist abuse. You know, at first that may not make sense, but really, you know, when a person gets to a place where others are always making decisions for them, which is something that was common in the disability community for many years. There was an assumption that people, especially with intellectual disabilities, needed to live in institutions. And what is an institutional life? It's a life where others make all your decisions for you, right? On what you're going to eat and what you're going to do during the day. And so when people begin to make more and more decisions for themselves, they're better able to recognize that it doesn't feel right when someone tries to take those decisions away from them. You know, when others make decisions for someone, that person over time can develop low self-esteem and have more difficulty functioning. They may decide not to even try as much. So some of the things to keep in mind about guardianship, there are a lot of disadvantages to guardianship. Guardianship is expensive and it's a lot of work. It can be difficult to terminate or modify. It requires a court order, which requires often the expense of getting an attorney to both establish the guardianship and then ongoing court oversight. Some people, when they file for guardianship, don't immediately understand that they have to file an annual report on how the person is doing with the court every single year. It also removes the person's self-determination and their decision-making rights and gives most decisions to another person who we call the guardian. The guardian becomes responsible for all the decision-making. So we have an opportunity now to hear from our friend Ricky Broussard, who's an important self-advocate here in Texas and just disability rights advocate and friend. So we're going to hear from Ricky about how supported decision-making has helped him in his life.
What is supported decision-making? A message from Disability Rights Texas.
Hello, my name is Ricky Broussard, and I'm at Disability Rights Texas. I'm here to talk to you today about supported decision making.
Supported decision-making is a way for people with disabilities to keep our rights and make our own choices with help from others instead of having a guardian who makes decisions for us. Guardianship.
people say guardians make it easier, but once you have a guardian, that guardian has control over you. A guardian is decided by a judge. You do not have control over any important decisions that you make. It shouldn't be that way because it's about the individual's life. It's not about their life.
Under guardianship, you can lose the right to choose where you live, how you spend your money, who you spend your time with, and other important decisions. Supported decision making.
Supported decision making. It's all about the individual. It helps us make the right decision for ourselves in our life. If you need help making decisions, choose someone that you trust. It doesn't have to be a family member. It could be somebody at school you trust or somebody at work you trust. After you choose somebody to support you, you tell them what you need support on and how they can help you. Some of the things that your supporter can help you do is going to the grocery store or make medical decisions or with where you live, or they can help over your finances. And my support team, I let everybody know, okay, this is what I need decisions on, and this is what I need you to help me with. After I hear the pros and cons of the decision, that's when I make the final decision on whatever choice I make. We all need help to make decisions. We have to make decisions every day. Your rights should not be taken away just because you need help.
To learn more, ask for the free book called Making My Own Choices by calling 512-454-4816 or toll free at 800-252-9108 or by video phone toll free at 866-362-2851 or by visiting www.drtx.org/choices. This video was brought to you by Disability Rights Texas. Find us on the web at www.ertx.org.
I love watching Ricky talk about how we all make decisions. You know, when we talk about decision-making options for people with disabilities, it's easy for us to forget that those of us without disabilities also need help making decisions. You know, at the age of 18, I didn't have all the challenges of a person with an intellectual disability, but I still ended up calling my mom and dad for advice and help with many different decisions, as most other people do as well. And so everything is completely normal about the basic underlying principle of supported decision making, which is just when you're having trouble making a decision or you need a little help, you can pick a person you trust to help you make that decision. When we think about supported decision making, it's just what Ricky was describing, someone who helps you weigh the pros and cons of making your decision. But there are other alternatives to guardianship as well. So here are kind of a list of main alternatives to guardianship. So a medical power of attorney. This is a document where a person indicates who they want to be able to make a medical decision for them. With a power of attorney, they can actually make that decision even if the person isn't, even if they were incapacitated at that time and couldn't make the decision for themselves anymore. Now, it is important, though, for a person to be able to understand that they're giving someone else the ability to make decisions about medical issues for them. Second, a durable power of attorney. A durable power of attorney is a power of attorney for everything else that's not medical. So there's a list of things on a durable power of attorney, and you can choose one or you can choose all of them, but it allows you to make educational decisions for someone. You know, I work with a lot of families who have special education meetings. Sometimes the adult students still want their parents to be involved and help make decisions after the age of 18. A power of attorney is a way to accomplish that goal. Again, as long as the young adult is able to say, yes, I want my mom to make these decisions for me, and then sign the power of attorney. So a declaration of mental health treatment is just a document that allows someone, when they're doing well, to make decisions for what kind of mental health treatment they would or wouldn't want, should they be doing not as well in the future. A representative payee, this is for Social Security. And so a lot of people who are considering guardianship, the adult will end up receiving SSI payments, and the Social Security Administration can designate another individual as the representative payee, who is then responsible for managing the individual's money to take care of that person. And so that's an alternative to guardianship, because you don't have to obtain a guardianship to be able to receive and manage a person's Social Security funds. Now, for families who are fortunate enough to have additional funds that they plan to use to support an individual with a disability, there are a couple other alternatives. There are ABLE accounts and special needs trust. So these are really only required when a family expects to be able to save money, that they want to protect that money in a way that the person keeps their Medicaid eligibility and keeps their other disability-related benefits. So if you put any savings that are going to be used for an individual with a disability in one of these accounts, then it keeps that person eligible for Medicaid and eligible for other important disability services. So ABLE accounts are just bank savings accounts, specially for providing for the needs of a person with a disability, that Congress created these to make it easier for people to save amounts of money of up to about $100,000. There's some higher amounts, but they come with more rules. So for most people, this is a good alternative to a special needs trust if you're going to be able to save up to or less than $100,000, then you can just go to a bank, and much like starting a college savings account, you can start an ABLE account, and no court has to be involved. For families who are planning to be able to save a little more money than $100,000 for individuals with disabilities, then a special needs trust is an important alternative to guardianship, and that does usually require hiring a lawyer to create the special needs trust and to designate a trustee to manage that individual's money. The important thing to keep in mind here is that a lot of families think that they need guardianship just for money management, but money management is actually one of the easiest things to accomplish for many individuals without a guardianship, because you can use the representative payees, the ABLE accounts, and the special needs trusts. Also, joint bank accounts. And at first, some people get confused about, well, how is that an alternative to guardianship? But, a good friend of mine, his main need for support was in managing money. And the way he received his support is he chose a good friend to be on his bank accounts with him. And they created a rule that when he got paid, his money would go into his savings account. That individual would help him pay bills. And then they would leave about $40 in the checking account, and he would have a debit card. But he knew that if he wanted to spend close to $40 or any more, that he needed to check in with his friend who helped him manage his money and have a conversation. And the purpose of that conversation wasn't for that individual to say, oh, yes, you can do that, or no, you can't do that. It was to help him weigh the decision. So I remember being with him one time, and he wanted to purchase, and it was a number of years back, so it was an iPod. And so he called that friend, and that friend said, well, you do have that amount of money in your savings account, so I can move it over if you like. But you had also mentioned wanting to go to this event this weekend that's going to cost a good amount of money too. It looks like you can only afford one or the other. Which do you prefer? And the reason I like to take the time to give that example is it just shows what supported decision making is all about. It's about helping a person weigh their options, but not make a decision for them. And so a joint bank account is one way you can do that, because in their arrangement, if he had decided, well, yes, I want the iPod, she would have just moved the amount of money it would cost into the checking account where he could easily access it with his debit card. So the supported decision-making agreements, this is what we have now in Texas. We have a form created by law that allows us to communicate to people, hey, I want to be supported in my decisions, and have this particular individual support me. In a way, it makes formal what people with disabilities have been doing for many, many years, which is to receive informal support from their friends in making decisions. So a power of attorney, those first two we talked about, it's a legal agreement. Someone else helps the person make a decision. But what's different here is it actually allows someone to make a decision for a person. It doesn't take away the person's ability to make a decision for themselves, but someone else can actually take the power of attorney and make a decision for someone, even if they're not with them. And so it is different than supported decision making in that way. And it allows, in areas where a person is no longer make the decision for themselves. So for example, some people, even as they're getting older, might choose to sign a power of attorney, knowing that at some point they won't be able to make decisions for themselves anymore. So they want to give that ability to maybe their son or daughter, for example. So how is a supported decision-making agreement different than a power of attorney? You know, both let other people help you with decisions, but in a supported decision-making agreement, the supporter helps make decisions, but the individual themselves, the individual with the disability, makes the final decision. In a power of attorney, the person makes decisions for another person when that person no longer can make them for themselves, or if they're not available. And an individual can have both agreements. And so very often we see young adults who want a parent or a friend to help them with supported decision-making agreements, but also may sign a power of attorney knowing that there may be times that they're not available and that they feel comfortable with someone making a particular decision for them as well. So now we're going to hear about a situation of a mom and a young adult daughter who made that decision to use supported decision-making instead of guardianship as their daughter turned 18.
It was important that I raise both of my girls to make decisions and live independently. But I think right now Timberly needs a little bit added extra support. It would be easier to make decisions for her, but that's just not the right thing to do.
My mom thought about guardianship, but then she was searching, and then she finally found supported decision-making agreement, and that was the choice to make.
Disability Rights Texas presents supported decision-making for young adults with disabilities.
My name is Tanya Mowat, and I'm originally from the Dallas-Fort Worth area. Timberly has what's called velocardiofacial syndrome. It's also called 22q. My goal was for Timberly to be independent, regardless of whether she has a disability or not.
I'm Timberly Mowat. I'm 18. I go to Bed Heights High School. I'm graduating this year, and I really like animation. I want to go into the Walt Disney Company and be an animator for them. That's always been my dream job.
Often when students with disabilities turn 18, school districts and parents lean towards guardianship because they think that is the only option they have.
The only paperwork I got from the school system was on guardianship. They handed me a couple of pieces of paper and the information on guardianship was one. Once you obtain the powers of guardianship, you lose all right to marry, you lose the right to vote, you lose the right to enter a contract, you lose the right to drive a car. You don't want mom having that power over you to make those decisions. To read the information on guardianship deflated me. When you listen to what the terms of guardianship are, you're stripping away the rights of that person.
With supported decision-making, a young person with a disability maintains her right to make choices and select someone she knows and trusts to help her. Both people complete and sign an agreement form.
We do have the supported decision-making contract in place. It has worked very well. We've been utilizing it for, I guess, 4 months now. We work really well together, always have.
My mom's always been there for me. She has helped me make decisions throughout all my high school. She helped me with what classes to take, like with algebra, what I take it this year to get ready for college. And then she helped me make decisions on that. And then she helped me.
Throughout Timberly's life, I've encouraged her to have a voice in her opinion. I tell her constantly that she has a right to speak up and she has a right to be heard.
It helps me because I have a mom by the side always, and if I don't want it, I can say no. It's better than guardianship.
If you are interested in finding out more about alternatives to guardianship, including how to create a supported decision-making agreement, visit sdm.drtx.org. Or if you would like assistance in creating a supported decision-making agreement, call Disability Rights Texas at 1-800-252-9108. Financial support for this video is provided by the Texas Council for Developmental Disabilities, with federal funds made available by the U.S. Department of Health and Human Services, Administration on Intellectual and Developmental Disabilities. The views contained herein do not necessarily reflect the position or policy of the funding agencies.
So who can enter a supported decision-making agreement? These agreements are designed for people with disabilities to be able to understand and to communicate that they want help with decisions. And they're really designed for adults. And so you have to be at least 18 before you sign the agreement. And you have to be able to understand in what I would say functional terms, what it means to sign that agreement. And so that's basically saying that I want my mom or my friend to help me with decisions at the doctor and at the bank or in other places. And who can be a supporter? It's any adult. And so it can be a parent or another family member, or it can be a friend. It can actually be a professional service provider as well, which can be an important support for some people who don't have families or other friends to choose. The important thing is that it's the choice is the person with the disability to choose who is their supporter. And what can a supporter do and what can they not do? So a supporter can assist people in understanding their options, their responsibilities and consequences, assist in accessing important records. So the agreement itself doesn't give the supporter the ability to request records on their own, but they can help the person with the disability request their own records. It can allow them to assist in communicating a decision to other people, especially, for example, with someone who may have a communication disorder of some type. Now, it doesn't allow, a supported decision-making agreement does not allow someone to make decisions for the person with a disability. It's still ultimately that person with a disability who makes decisions for themselves. So they can't, obtain records without that person's consent. And obviously they can't abuse or take advantage of a person with a disability, and any such conduct should always be reported. So now we're going to hear from another daughter and mom who also use supported decision-making, Dawn and Belinda.
Dawn was determined that she wanted to be independent. Guardianship would have meant that she would not have that opportunity. I knew that that was not going to work for her. I want her to be able to live her life. That's why supported decision-making is really important.
Disability Rights Texas presents supported decision-making for adults with disabilities.
My name is Dawn Carlton. I'm 39 years old. I live in Austin, Texas. I'm very independent and I enjoy having the freedom to be independent.
Supported decision-making is a way of helping a person with a disability make their own choices. The person can select someone in their life that they know and trust to help them make decisions.
Hi, my name is Belinda Carlton. I live in Dale, Texas, with my husband and a huge dog named Henry. I've been helping Dawn make decisions for a long time. Dawn is 39 now and has been living on her own for several years.
I asked my mom for help on medical decisions, going to the doctor if I need her to go with me. She helps me read the mail or questions that I need answered.
If there's something to do, does she understand what she needs to do? If there's a deadline, that sort of thing.
In 2015, Texas became the first state to pass a law recognizing supportive decision-making as an alternative to guardianship. The new law also requires that the court consider all possible alternatives to guardianship first.
Well, that's right. You had scoliosis, but it was that you had a herniated disc. That's right. And you kept saying the pain was unbearable. So you wanted to go ahead and go see a neurosurgeon?
Mm-hmm.
What did I keep telling you? That you had the right to change your mind?
Yes. I had the right to change my mind.
And you did it.
Yes.
It's her life and her decision.
Guardianship not only takes away a person's right to make everyday choices, it removes other important rights, like the right to vote, drive, and get married.
Guardianship would take away her right to vote, her right to get married. And she's done all those things. So that's a good reason for why not guardianship. Those basic rights that we all want to enjoy.
Well, independence is important because if you are out on your own, you could, just basically be free.
Just because she has a disability, just because has a label of intellectual disability doesn't mean that she cannot make her own decisions.
If you are interested in finding out more about alternatives to guardianship, including how to create a supported decision-making agreement, visit sdm.drtx.org. Or if you would like assistance in creating a supported decision-making agreement, call Disability Rights Texas at 1-800-252-9108. Financial support for this video is provided by the Texas Council for Developmental Disabilities, with federal funds made available by the U.S. Department of Health and Human Services, Administration on Intellectual and Developmental Disabilities. The views contained herein do not necessarily reflect the position or policy of the funding agencies.
So one of the most common questions that I receive when I give this presentation is, if people want to talk about their own child for good reasons. And some people ask questions about, what if my son or daughter doesn't make good decisions? And really, with respect to making good decisions, I think it's important to know that it is a learned skill that we all learn by making mistakes, and that guardianship alone doesn't change behaviors. Many of the decisions that people make are behavioral decisions of, am I going to try to run away, or am I going to, things that are behaviors. Guardianship doesn't change a behavior. But another line of questions is, what if my son or daughter or the person I'm worried about can't communicate that she wants help with the decision? And so if a person can't communicate that they want help with decisions, then they're not going to be able to sign a supported decision-making agreement or a power of attorney. Now, when I say communicate, I don't mean that they're able to explain in legal terms what these things mean, but they at least need to be able, in a basic way, to understand and communicate that they want help with decisions at the bank, at the doctor, in other places. And if they understand that, then I believe they should be able to complete these documents and use these alternatives to guardianships. Now, if you do have someone you're worried about who is not able to communicate that they want help with decisions, then that person can still use some other alternatives to guardianship. They can still have you appointed as a representative payee to manage their Social Security. You can still save money on that person's behalf in an ABLE account, protecting that money, protecting their Medicaid benefits. And you can still save money on their behalf in a special needs trust without taking away any rights from that person in a guardianship proceeding. The tougher issue for such individuals who aren't able to communicate that they want help with decisions is that if they need non-emergency medical care at some point, the doctor will likely need consent to provide that service. Doctors really vary in how they feel about whether they can get enough consent from a person to provide a service. So talk to the individual's doctors and decide if you may need a limited guardianship just for medical decisions. it's important that if you do go down that route, that you keep the guardianship as limited as possible. At least keep the right to vote, and think through every single right you might be taking away and think, is there really a reason to take this right away? Do people have to follow supported decision-making agreements? The truth is that Texas law encourages businesses to follow the agreements. Doctors and other professionals can't be sued or held responsible. They can't be disciplined by their professions if they're relying on agreement in good faith. And, I've given this presentation to doctors before, and they love that because there have always been a lot of individuals with intellectual disabilities who don't have guardians. That's nothing new. And doctors sometimes kind of want an insurance policy in feeling like they're able to honor that person's decisions to make decisions for themselves. And they feel like the protection given to them allows them to use these supported decision-making agreements and allow friends and family members to assist people in making decisions for themselves and for them relying on it. Also allowing someone support is a reasonable accommodation as well. Ever since this law was passed, our office has really been on the forefront of promoting these agreements and training people about them and helping families execute the agreements. And we have received very few complaints of people having any trouble. The reality is that most businesses want to allow people to receive help when they need it, and people just understand that adults with disabilities are going to need support and should be allowed to have someone help them with decisions when it's needed. So if you need help executing a supported decision-making agreement or need more information on other alternatives to guardianship, visit our website at drtx.org and then go to /SDM for supported decision-making. We have a comprehensive supported decision-making toolkit that has the forms that you can complete on your own. We also are happy to offer assistance for people who need help getting those forms signed and filled out. And so feel free to request our services if you need. Our statewide intake line for Disability Rights Texas is 1-800-252-9108. And you can also always do an intake on our website at disabilityrightstexas.org. And we have a sign language video phone and a Purple 2 video phone. That's numbers are on the screen. Thank you for listening today.